The broadcast is now starting. All attendees are in listen-only mode.
Okay, well, welcome to the Marshall Parker and Weber webinar entitled Medicaid Planning for Married Couples. My name is Matt Parker. I'm an attorney with the firm of Marshall Parker and Weber. And the purpose of this webinar is to give you some insights into the sort of planning that goes on to qualify for Medicaid when you're in a marriage. There's somebody typically going into the nursing home, and there's another person staying at home. So the question is, what happens to the money, the house? What is some of the planning that has to be done? There are all sorts of questions that do come up as to what we can do to qualify one person for the Medicaid benefit that pays for the nursing home costs and help, obviously, defray the rather significant cost of nursing home care. I'm co-presenting today with Patty Jo Turner. She's a longtime staff member, and we were talking the other day, Patty Jo, you've been here almost 20 years.
That's right.
Yes, so time has gone by fast, I presume, and all good years.
All good ones, all of them.
So we're going to begin the presentation. It will last about 30 minutes, and you can ask some questions, and we will hopefully have time to field those during the course of the presentation. All right, so let's get into our fact pattern. We've got a crisis nursing home case here. The two married individuals are Eugene and Darla. Eugene has dementia, and he's got some significant memory issues, and he's prone to wandering. He can no longer put his clothes on without some assistance. He can't remember to take his medications, and he's not going to eat without some assistance. So lots of issues going on with Eugene's health. As far as the assets go in this family, Eugene and Darla have a house, about $100,000 in the bank in various CDs, savings accounts, and checking account. Darla, she has a small IRA of $25,000, and they have two cars. Eugene has an old truck, and Darla has a Subaru. They both have income sources, and in this fact pattern, they're about the same, $1,500 for each person. Darla can no longer care for Eugene at home. She's decided to place him in a nursing home next week, and the nursing home is charging quite a bit for his care, about $10,000 per month. With his dementia, he needs more attention than some of the other residents in the nursing facility, so they charge a bit more for that care. Darla and her daughter Stacy have come to me for advice as to how to financially protect Darla when she places Eugene in the nursing home. So those are the facts of our case. We've got somebody who's entering the nursing home, a wife who's at home. She's concerned about losing what they have to the cost of care, and their question is, what can they do at this point? So one of the first things I like to get out of the way is, what are the sources for payment of long-term care? You essentially have three choices, and the two of them are on this slide. The paying privately for your care. You just use your own resources to pay privately. And of course, if I had different set of facts in this case, maybe they had $1 million, that's probably the route they would go. They would simply self-insure. The other way to pay privately is to acquire a type of insurance called long-term care insurance. Unfortunately, not many of my clients have that insurance. And Patty Jo, you've been in the insurance field before your time here, and you know that the long-term care insurance, it just hasn't been as popular as the companies would have liked.
No, it's really expensive,
Yeah.
and it was not popular 25 years ago. Yeah. So the folks who are aging into it now didn't purchase it then and couldn't afford it now if they wanted to.
Yeah, and so we see a lot of the companies are pulling out of the business.
Right.
They're just not able to make money on long-term care insurance. So let's just presume Darla and Eugene don't have long-term care insurance. So the other legitimate option is to qualify for government assistance to pay for Eugene's care. And that's the program called Medicaid. And here in Pennsylvania, we also call it medical assistance. One quick comment about Medicare. Medicare doesn't really pay for long-term care. And it doesn't pay for long-term stays in the nursing home. Medicare is a form of health insurance, and it's issued by the federal government in most cases. There is a private insurance plan that covers the basic Medicare that you hear about more frequently, the Medicare A and B. that covers skilled care, such as the care received in hospitals or the care provided by a doctor. There is very limited coverage under the Medicare program for nursing home care. Medicare is intended for skilled care. The skilled care is typically provided by a doctor or a nurse. In a nursing home, there's some type of skilled care, often through, let's say, rehabilitation. So if somebody's been injured and they're going to get some rehab and then they intend to return home, well, there might be a limited coverage under the Medicare program for that type of stay. But it's limited to 100 days maximum, and you have to have stayed in a hospital for 3 days as an inpatient. And being an inpatient is kind of important. You have to actually be admitted to the hospital for 3 days. So the classic case is somebody who slips and falls and gets injured, and they're in the hospital for a short period of time, maybe to have hip surgery, and then they are going to be transferred from the hospital to the nursing home for some rehab, and that would be skilled care, and you might get some time under the Medicare program to pay for the rehabilitation. But typically, you don't have any coverage under Medicare for nursing home stays. And even if you're getting some of these days under Medicare, Patty Jo, they don't often get the full 100 days.
Almost rarely do they get the 100 days. You're entitled to up to 100 days, but the skilled type of services that most residents need very often aren't needed past 30 days or 45 days. And so they're not going to be covered by Medicare beyond that point.
So when they improve or plateau, as the facility, actually the Medicare system tends to refer to the improvement as plateauing, and then the Medicare system will simply cut off their benefits.
Right. They say you don't need it anymore.
You can appeal and argue with them and ask for more days, and sometimes you're successful, but oftentimes you just run out of days, and then you're private pay or you're Medicaid eligible. So Medicare, not a solution for Darla in this case to pay for Eugene's care. It's the Medicaid program that we have to discuss. So they're going to need to apply for this program, and it's a joint state and federal program where your eligibility is based in part upon your asset level. And so we're going to talk at length about the assets and which ones are counted, which ones aren't counted. But Patty Jo, there is this other issue that Eugene has to be medically eligible to get Medicaid. What's the medical criteria? What are they looking for when somebody wants to get Medicaid, is in the nursing facility, and they're saying, listen, you need the type of care that this program is going to cover? What are the criteria they're looking at?
What will happen is they'll have an assessment done, and they're looking at 6 specific skills that would be being able to eat by yourself, bathing yourself, dressing, toileting, transferring, and to be able to manage continence issues. And if you need significant help with 2 or more of those tasks, then they would consider you to be an appropriate candidate for a higher level of care.
And it's the doctor certifying this, so the doctor's reviewing Eugene's situation. And I think in our facts, you saw that Eugene had a tough time moving around. He couldn't eat by himself. So he seems to be the type of candidate the doctor would certify as being medically eligible. And also our area agency on aging would also do an evaluation of him as well to make sure he met the medical criteria. So you can't just apply for Medicaid if you don't need the type of care that Medicaid is going to provide and cover. Medicaid is intended to pay for custodial care. It's the type of care in the nursing home, and it's intended to cover these sorts of activities of daily living. Getting out of bed, putting your clothes on, feeding yourself, toileting issues, all of those types of tasks are covered by the staff at the nursing home, and so Medicaid is intended to pay for that type of care. So the asset question comes up very frequently, and on this slide you can see the assets are broken down into available and unavailable resources. The amount of money a person can keep while on Medicaid can be rather limited. The theory is if the state's going to pay for your care, you shouldn't need a lot of assets in your name. Now, this is all about married individuals, and so we're going to learn that if you're married, you can actually keep a fair number of assets. You won't be impoverished. But if you were a single person, they wouldn't allow you to keep a lot of money and receive the Medicaid benefit. So the assets are categorized as the available assets, and the unavailable assets. Think of the available assets where the government will count these as those that are liquid. So if you have savings in the bank, whether it's CDs, bonds, stocks, those sorts of things, those are going to be counted. Anything that you can cash in and pay for your care. So for the person entering the nursing home, in this case it's Eugene, he's not going to be able to keep a lot of the monies in his name. He's going to keep typically $2,400, $2,400. Now, his number can actually go up to as high as $8,000 if his income level is not that high. But nevertheless, it's a small amount of these assets that we typically refer to as our savings, what we have in the bank or other investments. Now, if you're married, in this case, and you're not a single individual, then for the married individuals, there are spousal protections. The government will not impoverish Darla. So there are additional resources that one can keep for the healthy, or what we call the community spouse. These amount of resources are going to vary from case to case. They're generally calculated by adding up all of these available resources or assets. I use those terms interchangeably. Add them all up, and what you're going to do is you're going to cut them in half. So if Darla and Eugene have a total of $100,000, well, they'll cut that number in half. And half of that is the amount that Darla will be able to keep as her own. Now, we're going to talk a little bit about unavailable assets in a moment that she can also keep, but those liquid assets, they generally just cut them in half. Now, there is a maximum that you can keep. So just don't think that if you're a millionaire, you can keep $500,000 for Darla, and it's not going to be allowed under the Medicaid program. They have a max. So right now, the maximum is $123,600 that Darla could have kept. If she had a large amount of money, let's say $300,000, she could only keep a maximum of $123,600. And that number changes periodically. It's 2018 while we're taping this webinar. If you listen to it in 2019 and beyond, that number will be different. Okay. So one of the key planning techniques we'll discuss is rendering some of these available assets unavailable. So you don't have to spend them all on your care, and consequently it's easier to qualify for the Medicaid program. Some people don't do any planning, and they just spend the money down. They just take the excess resources and spend it on the nursing home care. And that's fine. If you just want to keep paying the nursing home bill, you can, but there is, in fact, some planning techniques available to you that the government allows you to engage in to qualify for Medicaid. The other type of assets on this slide are the unavailable or exempt ones. So you have exempt assets that the government just won't count when you're applying for benefits. The largest of them is the house. And when you're married, it just doesn't matter how valuable your house is. So you can have $1 million home and the government won't count it. Now think about how the inconsistency there. You might have, only $200,000 in available assets, but you have a very valuable home and the government will not count it when you try and apply for this program. Now, as we're going to talk about in another slide or two, the house may, in fact, be exposed to a program at your death called the Estate Recovery Program. So you want to be careful about how the house is titled. So you don't want it exposed to pay for the cost of care after a person passes away. The other unavailable assets include your car. You can have one car of any value, and your personal possessions as well. The government doesn't count the stuff in your house. And we're going to now move on and talk about something that makes a lot of sense when we're talking about these available assets. People will say, well, if I have too much money, can I just give it away? Can I just reduce my assets by turning over this money to my child? So we do have a child in this case, Stacy. Well, if everybody could just turn over all the excess money to a child, the entire population would qualify for Medicaid. So the government realizes this and set up some rules that restrict your ability to qualify for Medicaid after you make a gift of money or property. So here's how the rule operates. If you've made a gift of assets, and that could be cash, it could be a car, it could be real estate, within the last 5 years prior to applying for Medicaid, you're going to create a period of ineligibility for you and your spouse, a period of ineligibility for the Medicaid program. This 5-year period is called the look-back period. It changes occasionally. Right now it's still 5 years. They haven't altered it in some time. It's been 5 years, well over a decade. So if you gave away any assets during the last 5 years and you are now applying for benefits, this period of ineligibility will run after you apply for Medicaid. So it doesn't run when you make the gift. It starts when you are otherwise eligible for the Medicaid program. So that can be rather an unfortunate consequence. If you've given a lot of money away in the last 5 years and suddenly Eugene has to go into the nursing home, Darla applies for Medicaid and realizes, Eugene's not eligible for 6 months. And she's got to come up with money to pay for his care for a 6-month period. That can be an unfortunate consequence. So people, as they're getting older, need to be very careful about giving away assets when there is a significant risk of needing nursing home care in the future. So anybody with dementia, that sort of condition, you may want to be very careful about giving away assets. Now, Patty Jo, you and I do a lot of planning for otherwise healthy people who are transferring assets. We create a lot of irrevocable trusts for them, and they're putting what in those trusts? Typically the house.
They often put in the house. Life insurance is a great thing to put in there because they just don't miss it otherwise. And assets that might have appreciated, things like an investment account or deferred annuities that they've had for some period of time.
Yeah, so they can take assets and shelter them in one of these trusts, provided they're doing so 5 years ahead of time. The government's just not going to ask about it. Okay, so there's a lot of planning that goes on to try and shelter assets well before you're facing a financial crisis, and it's perfectly legal to do. You just have to be planning ahead. If you get into a crisis situation and you're trying to give away assets, it can be very difficult, such as in Eugene and Darla's case. There are some exceptions to the gifting rule. One of them is to a disabled child. So if you have somebody in the family who qualifies under the Social Security disability rules, is getting SSD from the government, you could in fact transfer assets to this child, so and not have a period of ineligibility. So even if you did it within the last 5 years, you would not be ineligible for Medicaid. So if Stacy had SSD, that's one of the questions I would ask her when she came in with Darla. Do you have Social Security disability? And if so, I could transfer assets to her in an effort to protect them from Eugene's cost of care. So, the other way you can transfer assets is to a child who provides care to the parents in the parent's home for a period of 2 years prior to entering the nursing home. We can actually transfer a home, the parent's home, to this child, provided the child doesn't have another place to live in. It's a classic scenario where the child leaves their place of employment, comes home to be with mom and dad as they're getting older, and provide some care to them so they can stay out of the nursing home. If the doctor certifies that that child provided the care and it kept them out of the nursing home, then we could transfer the home to Stacy in an effort to protect the house from either Eugene or Darla's care that could occur in the future. So there are some exceptions to this gifting rule, but those are the two, the common ones that we use. And so you got to be really careful about giving away assets as somebody is getting close to the time they might need nursing home care. Here's another slide to talk about what happens after somebody passes away. There is a program called estate recovery. And essentially, the government is keeping track of how much Medicaid you are getting during your lifetime. So when Eugene enters the nursing home and he qualifies for Medicaid, there's going to be a record as to how much Medicaid is paid to the nursing home towards Eugene's cost of care. And if Eugene passes away, the government has a right to ask, what did Eugene own in his name when he died? And if he owned, let's say, a home, the estate recovery program is allowed to put a lien on that home. And when it is sold, the money associated with the sale of the home has to first go to pay the lien that represents the amount of Medicaid that was paid towards the cost of Eugene's care. It's a rather unpleasant program. A lot of people aren't aware of it. They think that Medicaid is somehow free, and you just get it, and the government doesn't want something back from you at the time of your death. Not necessarily so. What we do at the law firm is we are very conscious of this program, and we want to make sure Eugene doesn't own the house when he dies, and he doesn't own bank accounts. He doesn't own anything. And he shouldn't own bank accounts because he can't have any money while he's on Medicaid, but he shouldn't own anything so that when the government says, hey, did Eugene own the house? He doesn't. In fact, we typically put the house into Darla's name. We make sure that Darla can use and enjoy the home during her lifetime. And we hope that Darla does not need care. Obviously, if Darla needs care in the future, the home could be exposed to her care. Thus, one of the reasons a lot of married couples are creating these trusts 5 years ahead of time. They put the house in the trust and avoid this whole estate recovery program altogether because the government cannot put a lien on a house owned by an irrevocable trust. So when you're doing planning, you've got to think about this estate recovery program and make sure the house is not exposed to Eugene's cost of care. So some of the planning techniques here, Patty Joe, we're going to advise Darla what to do here. So we've got some money in the bank, about $100,000. Does it really matter whose name are on these accounts?
Actually, no, it doesn't. The state will look at assets, whether Darla owns them, Eugene owns them, or they own them jointly. They'll consider all of them to be available to pay for the cost of Eugene's care.
Okay. So one half of these assets are protected for Darla. So we got $100,000. So her share is $50,000.
Right.
And the maximum again would be what?
The maximum is $123,600.
That's right. So what other assets are protected as unavailable? We've got several of them here.
One of them would be the house under the right circumstances.
Yeah.
If you have more than one car,
Yeah.
then one of the cars is protected. And if there is an IRA that belongs to the spouse who's staying at home. So in that case, that would also be unavailable.
So Darla's IRA is exempt. Her Subaru is exempt. So is the car. And with the house, would we leave it in both names, or do you typically move it into Darla's name?
You know, generally, we would choose to move it into Darla's name because, heaven forbid, Darla should pass away and the house is in both their names. Then Eugene's going to inherit it, and now the house has become exposed to the Medicaid estate recovery plan.
Right. And the second car there, Eugene's got an old truck. That would just be part of Darla's share there, that $50,000.
Sure, that could just count as part of what she's allowed to keep.
All right. And the beneficiary on the IRA, it probably was Eugene. Would we change that beneficiary?
It's a good idea to change that because, again, if Darla should pass away first, it is not advantageous to have Eugene inherit her entire IRA. It's a lot more protective if the children could be named as the primary beneficiary.
Now, both of them have some rather modest income. So Eugene's heading to the nursing home. When he goes on Medicaid, does his income have to be paid to the nursing home?
It does. Every month, his income is what they call part of his patient pay obligation. And the state will want him to contribute his income. And then if he's short and he qualifies for medical assistance, then they'll pick up the difference.
But Darla's allowed to keep a minimum amount every month because the government says she needs enough money to live on, okay, the MIMNA. So how much is she allowed to keep? And in these numbers will change periodically. Isn't it a little over $2,000?
It's a little over $2,000. I think it's $2,030.
Yep. So she's allowed to have $2,030. If she has really high household expenses, she might even keep more of that. Those are called shelter expenses. So Darla's allowed to keep enough to pay for the household costs. So some of the options for spending down, if you don't want to just spend all the money on the nursing home, we got Eugene's share of $50,000. What are some of the things he can spend it on? What about burial arrangements, Patty Jo?
Burial arrangements are a great one. Everyone's going to incur a burial expense. That's a legitimate cost that they can pre-plan for. So that's a good way to put some money aside. They could maybe purchase a new or newer car for the spouse who's at home, pay off debt. There's often some home equity line of credit or some credit cards, and those can be paid off. That's a legitimate way to spend that money, and it lets the spouse at home become debt-free. That's one good way to do it.
And there are some retroactive expenses. So they had outstanding medical bills; those would be retroactive to the date they applied for Medicaid, and also burial costs. So you've got some retroactive, but most of them, if you're going to spend down, you got to act quickly. You want to buy a new car, hustle out there and get a new vehicle for Darla, so that money can be spent and not counted against them when they apply for Medicaid. And you don't do any of this until Eugene's in the nursing home.
Right.
Nobody's spending down before Eugene gets in the nursing home, and he's not coming back. One of the options for protecting assets is a Medicaid annuity for Darla. So if they don't have all these other things to spend down on, or maybe they had more money, you may want to set up a Medicaid annuity for Darla. Patty Jo, you deal with annuities a lot. How do these contracts work?
Okay, so let's say that Darla's got a sum of money that's making Eugene to be over-resourced and not qualified for medical assistance. But that sum of money could then be used to purchase an annuity, and the annuity could be set up to pay income to Darla. So the assets that were exposed and disqualifying him are now what they would consider income, and Darla's allowed to keep the income that's hers. So that will help give her some security financially as time goes forward. The annuity would be set up so that it would pay Darla for a specific period of time. And it's all part of the plan, figuring that out, but it would never last longer than her life expectancy.
Yep, and a lot of times we'll set these up for 5 years or less. So if you have $50,000, Darla would get $10,000 a year in this annuity. And again, if Darla lives long enough, she gets all the money back from the insurance company, and she just puts it back into her savings account. One of the downsides is that if Darla dies during the term of the annuity, the government does have a claim to the annuity for what wasn't paid to Darla. So if she got $40,000 back, but there was 10 grand left, the government would get that money. So these are good contracts for somebody who's healthy. So we've got to look at Darla's health and make sure she's going to live, hopefully outlive Eugene and get the benefit from the annuity.
Yeah, it's a great planning tool, but the facts have to fit. So
Yes.
when they do, this is a really good way to go.
And we talked about this morning, Patty Jo. Not all companies are selling these Medicaid annuities. There's only a handful of them out there, so you got to be very careful. Work with an elder law attorney and get the right product for your loved one. And the Medicaid application process can be very challenging. There's a lot of documentation that has to be gathered. Patty Jo, you've been working here quite a while and you've done a few of these applications. Don't they take a lot of time?
They are really time intensive. You have to gather and document all of the assets that a couple owned when Eugene goes to the nursing home, for instance, and they will often ask for up to 5 years worth of statements on all the assets. So it gets to be a very big pile of paper. You submit all of this to the county assistant's office, and they'll go through it and look for anything they have questions about and let you know, hey, they're still over-resourced, and at that time, you have to act and decide what needs done to help spend down and get Eugene on benefits. So spending is often a part of the plan.
Yeah. And a lot of times the government will come back and say they want more information. They'll find something in the documentation. So you go back and forth with them to try and establish his eligibility. They're kind of on a fact-finding mission. They're trying to figure out what this person had in the last 5 years. They even ask about closed accounts. So there's a lot of work there detailing what this person owned, what they did with their monies, and explaining it to the government before you become eligible for Medicaid. So it's not, or anybody who's been through it, you understand it's not a very quick process. It can take months. All right. Our last slide here is about some documents we want to put in place for Darla. And probably Eugene, if he doesn't have a power of attorney, and let's hope he can still sign one, because if Eugene's dementia has gone too far down the road, he may not be able to sign a document for himself. So in most of these cases, we hope our clients have early on in the process. That is, when Eugene was initially diagnosed with dementia, they came in and they got new documents done, knowing that many years down the road, they may need to qualify for government benefits. And these power of attorney documents that allow you to do all sorts of things associated with qualifying for Medicaid. You may have to cash out assets like stocks, and you need Eugene's signature to do that. Or maybe you need to transfer assets out of his name, like a life insurance policy, or take his name off the title to the home. You can't do that either without Eugene's cooperation unless you have a power of attorney authorizing Darla to do so. And some powers of attorney are very simple. They just say, hey, basically you can pay my bills and manage my assets. They're very conservative in terms of their content. Others are very broadly worded, and they'll say things, you can do all things necessary to qualify me for Medicaid, including transferring assets out of my name, liquidating accounts, liquidating IRAs. All of these things sometimes have to do when qualifying someone for Medicaid. So if you're potentially the sort of person who might need this benefit in the future, get your power of attorney looked at to make sure it has the appropriate powers so your loved one can help qualify you for these benefits. And we'll also want to recommend that Darla update her will. It probably says, I leave everything to Eugene if I die. Well, if we're transferring everything to Darla, we don't want her to die and leave everything to Eugene, who's on Medicaid. So we will have to disinherit Eugene, maybe leave some money in trust for him, but we don't want to leave him a lot of the assets. So there is a type of will where we can use a special needs trust in Darla's will for Eugene's benefit. So we can leave some money to him that's not exposed to pay for his care, but we don't want to leave him the entire estate, otherwise it unravels the plan. So that concludes our webinar. I hope that gave you some insights into Medicaid planning for married individuals. There's a lot more to this sort of planning than we could cover in 30 minutes, so don't hesitate to give our firm a call if you want to learn more about Medicaid planning, or visit our website at paelderlaw.com. Thank you.